Good morning, Mr. Martin. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 8, 2025, officers were dispatched to a weapons call at 821 Dorchester Street in Harris County, Texas. The caller stated that there were about 10 people fighting, and the caller saw a gun. The officer observed a multitude of people walking from the street into the property and saw the defendant fitting the description as the person with the gun. The officer approached the defendant and he admitted to having a gun on his person. Upon the frisk, the officer felt the outline of a firearm in a crossbody bag on the defendant's person. The officer removed the handgun from the bag. The defendant is 19 years old.
What's he doing wrong? All right, I'm going to find no probable cause in your case, Mr. Martin. Be careful. You know, you're 19, you have a gun. God forbid you use it. Put yourself in such a deep hole. You know, really. Go to school, get some knowledge, get a good job. You'll get a ton of money, and then life's great. Life sucks without money. I promise you. Don't end up in a hole, hang out with dogs, because all you're going to do is get fleas, you know? Take a seat, please. Good morning, Mr. Wolf.
Good morning, sir.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 7th, 2025, Officer 1 was dispatched to check by a unit at the 3800th block of Redville Street regarding a minor crash. Officer 1 made contact with Officer 2, who on-viewed a two-motor vehicle accident. Officer 2 observed.
Right off the bat, you can tell Judge Fleischer runs a tight ship. But here's the thing about good judges. They're not just referees, they're psychologists in robes. They're reading body language, tone, who's telling the truth, and who's rehearsed their lines a little too perfectly. Watch how he locks in on the defendant here. That's not just eye contact. That's an interrogation.
The defendant operating a silver Ford minivan and crashed with a black Honda Santa Fe. Both drivers were moved to a gas station. The witness observed the defendant driving the silver minivan and stated she observed the defendant crash into her. The officer observed the defendant to have bloodshot, glossy eyes and sluggish speech and poor balance. SFSTs were administered. 6 out of 6 clues on the HGN, 5 out of 8 clues on the walk and turn, 3 out of 4 clues on the one-leg stand. The defendant was placed under arrest and read the DIC, and he consented to provide a blood specimen.
It's not back.
No.
Prior to your BI, one from with us or any more?
It looks like there is a pending DWI from Galveston County from back in 2021.
Can you please confirm whether that is actually pending now? Because I'm going to have big issues if that is actually pending. Please. I'm going to find that there's sufficient probable cause to go forward with your case, Mr. Wolf. I'm ordering you now. Just take a seat for me in the jury box. I'm not ready to go forward. I want to know if you have an open DWI. Come up, Mr. Wolf. Guys, I have found that there's probable cause to go forward with your DWI second in here. You also have another DWI in another county. Stop.
Okay, that was driver not licensed.
Stop.
Yes, sir.
I don't want you to say anything. I will appoint you a lawyer today, but it's unacceptable that you continue to pick up cases here, there, everywhere. Unacceptable. And I don't think that a PR bond is the right thing to do. I'm now going to revoke the PR bond and he goes with you. You're a danger to our community. That's unacceptable.
Just driver.
Stop. I will appoint you a lawyer. I don't want you to say anything now. I would like, did you talk to a lawyer? Can you appoint him someone, please? You are not to drive at all. I don't care what you're going, what you need to do. Do not drive. The only thing I'm asking you to do is please don't kill someone on our roads. That's all I'm asking you to do, man.
Yes.
Every single day, we have an intox man, an assault that happens because of this.
I'm fantastic.
Stop. There is probable cause to go forward. We have trials to determine that, but I have found that they're sufficient to go forward. You've got multiple cases open in another county. It goes with you. I will appoint your lawyer. You tell your side to the lawyer, and then we can talk after. Ready?
Judge, may we approach on bail on Mr. Wolf?
Okay.
Your Honor, as you know, I mentioned that information, so we did look it up on that case. Wilson Galveston, that it was active, but we just looked it up on their public records, and that DWI, the same cause number on the NCIC was dismissed.
But he still has open Galveston cases.
Still has open Galveston cases there for, I think it's a possession of marijuana and a driving without a license. So those are the two, the DWI is not.
Did you ever bring him out? Mr. Wolf?
He's over an 8. And Judge, I did not talk to him all about the facts of his case, and normally I do before I approach. I just wanted to reapproach on the bond, so.
Yeah.
I've already told him I'd make an appointment to talk to him.
Have you run his license?
I'll run it right now. He is not eligible.
That's too much.
I think it's what happened. The clerk looked, it's like driving without a license, and just assumed that it was driving while intoxicated.
Yes, probably so. You said he does have
Yeah.
charges in Galveston?
He does.
Possession?
Someone locked the back gate and left it open for you. Now it's
Driving
closed.
with license. And then
That's, yeah, so.
Yeah. Let me make sure they're still there.
Yes, ma'am. Yes, ma'am. I mean, I
It's
got a
okay.
job. I take probation. I got ankle monitor or something. I got a job and all that. I was thinking and I was trying.
I'm gonna help you, but let's try to get it, let's at least try to get it lower to get you out today.
I'm going to do everything in my power to protect my community
Yes, sir.
at all costs. I don't care who you are. I don't care what color you are. If you're a small farm animal, everything in my power to protect my community.
Yes, sir.
You have 2 open cases in Galveston, and now you've picked up a case here. Does he have a license?
it's not eligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive, Mr. Wolf. And I want you to understand and hear me crystal clear that if I find that you drive and I don't give a rat's behind what your excuse is, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every single time you drive. I don't care that you need groceries. I don't care that a kid has to go to the hospital. I don't care that there's a burning building and you have to save 50 kittens. If you don't have a Texas driver license and liability insurance, then you're not to drive. You now stand charged with the DWI second in this court. I am now also placing an additional restriction on your license that you're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle and it doesn't have an interlock on it, because I send notice to DPS in Austin so that every police officer in this state knows you get pulled over, you don't have an interlock on that car, they will take you directly to jail. I'm going to honor your PR bond today, but I'm putting a whole host of restrictions on.
Quick legal breakdown. That objection? Valid. Judge Fleischer just saved this case from going off the rails. In civil court, evidence rules exist to keep things fair, not to be technical just for the sake of it. If he let that slide, The whole dynamic shifts. Good judges kill bad arguments early. Great judges make it look effortless.
You. And if I find that you violate these restrictions, I will violate that bond. Do you understand?
Yes, sir.
You are not to consume alcohol, illegal drugs, and I'm telling you, I'm going to test you within the next couple weeks to see whether you are using. If 50 plus days have passed and you test positive for marijuana, it's not going to go well for you. Do you understand?
Yes, sir.
The only thing I care are my streets and that they're safe. And if you don't have a license and you ain't got insurance, then you're not going to drive. You will now get a portable device that you're going to take everywhere you go to prove to me that you're not using alcohol. And I'm telling you now, I'm going to test you for weed here momentarily. Hey. They filed 2 surrenders on Mr. Galvan's case. I just need to know your position. I sent you a picture of it. Can you just take a look and let me know what you say? Correct. Okay, just wanted to know. Okay, thanks, Shane. All right, take care. I'm honoring our bond. I'm letting you out. You hold the keys to this jail cell. You know what's expected of you. You pick up a 4th case. I'm going to go cuckoo for Cocoa on your bond. Do you understand?
Yes, sir.
We have also given you a lawyer. It is your responsibility to stay in touch with her. If she tells me she can't get a hold of you because you've gone AWOL, you've taken off, picked up a new case in another county or whatnot, that's it.
Give him a card before you take it from in there. Oh, okay. Thank you.
We'll have you come up here, swear to us that you're not going to drive. I will get you to Victoria where you will sign a reset. You will then get with Fleischer for your bond conditions, and then you guys can talk about this case. Don't pick up a 4th case. Okay? All right, Ms. Teachy.
Judge, may I be excused? I've made arrangements to talk to him about his case. I'll give him a call.
You ready?
I am always ready.
Let's rock and roll.
Judge, was this one CHA?
No, I gave her an application.
So it's smoking jacket thing, Judge, that I just not
You did. It's okay.
smoking.
Well, it's too early, man.
Yeah.
Come on up, sir. Is it De Los Santos you said?
Yes, and it was under Santos
Yes, page
on the
19.
docket, but it's.
I see it. Got it. All right, Mr. De Los Santos, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high blow. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 9th, 2025, at approximately 6:34 a.m., an officer responded to a major accident on the 6100th block of North Fry Road in Harris County, Texas. The officer made contact with the witness, who was traveling south on North Fry Road, and stopped at an intersection of West Little York Road, and he began to drive. When the light turned green, he was struck from behind. He exited his motor vehicle and observed the defendant in the driver's seat. The officer observed rear damage to the witness's motor vehicle. The witness stated the defendant was transported to the hospital. The officer observed heavy front damage to the defendant's motor vehicle, but no closed or open containers in his motor vehicle. The officer made contact with the defendant at Katy Memorial for Mental Hospital. The defendant stated that on March 8th, 2025 at 6 p.m. he was drinking at a friend's house. The defendant stated he drank until 4 a.m. the next morning. He admitted to driving under the influence, resulting in a major accident. The defendant had visible scrapes and injuries on his face, arms, and legs. The officer observed the strong odor of alcohol upon his breath, red bloodshot eyes, and slurred speech. SFSTs were administered. 6 out of 6 were observed on the HGN. The walk and turn and one leg stand could not be conducted due to injuries. IVs, and the defendant had IVs, and the defendant was wearing a neck brace. The nurse checked his vitals and ensured the defendant was in good health to be discharged from the hospital. The defendant was read the DIC and agreed to a breath test. The results were 0.166 and 0.169.
How long from the time of the accident to the time that he goes to the hospital? Is it immediate?
So I don't believe it states what time the accident occurred and what time he was transported to EMS, or transported to the hospital, but it's before the officers were able to arrive on scene and do an investigation of the accident.
He doesn't write down what time the accident is? Do you have the OR?
Been a lot of that going on lately in DIMS.
I don't understand who's writing these reports.
I don't know, I thought intake was
No,
supposed
I
to
don't get it.
improve on January.
It's, it's important to know how long it takes him to get to the hospital, right? And then I guess he's discharged immediately after he gets to the hospital. I mean, that can't be because he does, how long does it take to get into an emergency room? It takes forever. When I have a family member that goes to the hospital, it takes 12 hours just to get seen.
Yeah.
And then he goes and he blows a 16 after. I mean, I don't know, look, I'll give you a little bit of time. Take a look to see.
And getting, hopefully the office report can clear it up. We don't have that back yet. Correct.
I just want to know that there's not a disconnect. Like it doesn't take 12 hours to get from here to here. Because you know how long it takes to get to hospitals and it's ridiculous. So yeah, I'm going to put it on hold for now because we got a whole.
Just today or?
No. Later, like I'll give him a couple, like maybe an hour or so. Do you have
Okay.
anywhere else to go?
I have plenty of places to go.
Yeah, I bet. So go do what you need to do. Come back. Let's revisit PC in a little bit, will you? Please?
Absolutely.
Okay. Take a seat. You're in the juror box. Don't leave. And then I think that we need to do a name change because they have it under Santos, but his name is De Los Santos. De Los Santos is the last name, not just Santos. Nathan, and it's De Los Santos.
That's correct. All three separate.
Do a name change. Right. But it starts with De Los Santos. Right. So that's, yeah, we're gonna do a name change.
So we do have the office report back.
Okay. Are you ready now or do you want some time to look?
Can we have? Yeah.
Can I make a suggestion?
Sure.
Based upon the offense report not having any, go ahead and stand here, and the DIMS report not having the information that they're seeking, I think at this time, no problem cause finding is appropriate. However, it's my understanding that Chief Pace, since I trained him, will probably go and figure out all these facts and get it refiled correctly.
I wanted to give you a little bit of time. If,
Huh?
huh?
I'm going to contact the officer.
And we already
I didn't want to go
have,
that far. I wanted to just see what the report has.
And
Because you being able to go contact the officers a little bit just beyond this, because it's not fair to them. But what I'm looking for is how long it takes from the accident to get to the hospital, to see, is it him that's driving? Is he intoxicated at the time of driving? Because that's what it calls for, right? That's what we need to know. So if you can just take a look real quick, go do what you need to do, come back maybe like 45 minutes. I just want to know what the timing.
I was just going to suggest, we already have a date of 4/14, that they can get this done in the interim and not have to scramble today with 50 other arraignments. That's all I was suggesting. But it's up to the court.
Looking at the OR, the timeline is not.
It's not in there.
For that.
They put any time in the OR?
The times that I have is that the witness said that they had been there since 6:30. Sorry, I don't know what that is about, but the only time that I have is that the blood sample was taken at
Breath right.
8.
Breath right.
Wait, did you catch that? That just changed everything. In court, the most dangerous thing you can do is contradict yourself. Once a judge catches you in an inconsistency, your credibility tanks. Fleischer's face says it all. He just made a mental note, and trust me, he won't forget it.
He didn't write down what time the accident happened? Or what time he gets on the scene? There's got to be something, Look at the MDTs, there's got to be a time when
Sorry, I'm looking at the wrong offense report, Judge. I apologize.
It's okay.
I do have, based on the accident report, the crash time was 5:50.
in the morning. And I'm not seeing, what we don't have your honor is, I think it's time. But,
I'm not concerned about that. I'm concerned what time he gets to the hospital.
yeah,
Crash occurs at 5 something in the morning.
okay. And
Does he get
he's
to the-
admitted to the emergency room at 7 a.m., so it's roughly about an hour after.
Well, he gets admitted at 7 a.m.
Yes.
Okay, so we're about an hour and a half after the crash. What time does the officer get there? Start interviewing, do you know?
The crash is at 5:50 a.m. The officers transport the defendant in at 6, so 10 minutes later. And
They transport him to the hospital.
yes,
Okay.
it's admitted into the emergency room.
What time does the officer get there to start the interview? Mr. Beadle, I just want to know that everything is in close proximity because if he gets there, he starts interviewing like 12 hours later, I'm going to have a problem.
And I think the DIMS will probably be supplemented appropriately. I know how much business you have today. I see all the arraignments here sitting in the audience. I think that they will get it done by the 14th of April, which is what I already have the date for. But I leave it to the court's discretion. I'm fairly certain it's not in there. You're doing great, by the way.
Your Honor, I don't see a time, and it's in front of the hospital.
And the blood draws what time?
It's at,
Or the breath test, sorry.
Which is weird in and of itself, Judge, because they said he couldn't do the one leg stand or the walk and turn.
Because
But then they took him off to another location to do a breath test. It's just kind of weird.
it doesn't state that.
you don't even have the time of the breath test?
I get it, no.
So it looks like we're looking at her bond. I would ask that report, she would leave right to review it before considering it.
What do you think?
We have a date for the 14th. I'm sure they'll do it before
Okay.
then. His appearance is waived anyway, so he doesn't have to be here.
Okay, so,
Do you want to put some potential conditions on
No, I
him,
never-
assuming? Okay.
so I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. Any prior DWIs? And valid license?
No prior DWIs and his driver's license is valid.
Okay, as long as you have valid liability insurance and a Texas driver license, you may continue to drive. But if you don't have car insurance, do not drive. It is a condition of your bond. Don't consume alcohol, don't use illegal drugs. Do you understand?
Yes, Your Honor.
We'll waive your appearance while you're on bond in this court, but you must stay in touch with them. If they tell me they can't get a hold of you because you're ducking and dodging or you pick up a new case, all bets off. I will put you in jail. You
Absolutely.
understand? Okay, I'll have you sign a reset with Victoria. We'll get you with Fleischer, your bond condition, then you're free to go. All right, Mr. Beadle, always a pleasure. Happy Friday.
Have a great weekend.
You too. Good morning, ma'am.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, ma'am.
On March 9, at approximately 3:14 a.m., the officer observed a vehicle driving without taillights and swerving in its own lane side to side. The officer
And there it is, justice, delivered with side of reality check. Judge Fleischer showed us today that court isn't about winning on a technicality. It's about walking out with a fair shake. What did you think? Fair ruling, or would you have gone the other way? Drop your take in the comments and stick around. This courtroom's just warming up.
observed the vehicle failed to maintain a single lane and merged into another lane, almost colliding with the vehicle in that lane. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and she was identified by her Texas driver's license. The officer observed the defendant to have bloodshot eyes, with a speech and odor of an alcoholic beverage on her breath and person. The defendant stated that she had 2 tequila drinks. SFSTs were conducted. This is 6 out of 6 on the HGN, 4 out of 8 on the walk and turn, and a 2 out of 4 on the one leg stand. The DIC was read and the defendant consented to breath. The results were a .137 and a .132.
Okay. Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. Can you also look prior to WI's license, please?
Yes, Your Honor.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Judge, on the testing, what is that? If I can pass on that message.
Just random testing. No alcohol, no dope,
Okay.
illegal drugs.
Yeah, I guess just so I can pass it on, if there's a pattern of nothing, can he reapproach in the future?
Of course. It's gotta, I mean, don't come in 2 weeks though.
No.
Right. But yes, of course.
License is eligible, no party.
Okay, so you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you when you have to come back to court. As long as you don't pick up any new cases, we'll be fine. I'll have you sign a reset with Victoria. We'll get you with Felicia for your bond conditions, then you're free to go, man.
All right, thank you very much.
Have a good day.
Don't put your stuff on the table.
Yeah.
Right here in front of the judge.
Good morning, Mr. Robinson.
Good morning, sir.
Sir, you're charged with terroristic threat. You are facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 7th, 2025, in Harris County, Texas, at 315 Capitol Street in Houston, Texas. The complainant is a security guard for the building and was walking around Bagby when he found the defendant sleeping on the sidewalk. The defendant was not supposed to be there, and the complainant told him repeatedly that the defendant was not allowed to be there until around 11 p.m. at night. The defendant then began to get hostile and aggressive and threatened to shoot the complainant while slowly reaching into his bag. The complainant feared for his life.
Did you say he's not allowed to be there until 11 p.m.? Did I hear you say that? What is it?
I don't know. When the complainant, we did not charge a trespass in this case. So when the complainant said you're not allowed to be there, we back at 11, and that's when the responded.
Can you say it again? What did he say again?
Complainant repeatedly told the defendant that he was not allowed to stay there until after 11 p.m. to 7 a.m. And since it was before 11 p.m., he was there for trespassing and not allowed to be on the premises. The defendant had threatened the complainant that he was going to get his gun and shoot him by signaling this might go in his bag with his field first.
He said, I'm going to get my gun and shoot you?
I don't have it both ways. Say the complainant, defendant threatened the complainant that he was going to get his gun and shoot him, signaling this by going to his bag.
Ask a question.
Who wrote the report? The actual officer who got threatened or someone else?
The officer did not write the report. I mean, the officer wrote the report, not the security guard. The security guard is the one who was threatened.
Mr. Robinson, I'm going to find probable cause for now. Okay. Let me give you a lawyer. Talk to the lawyer. Just don't have any contact with the security guard. That's the only thing I'm going to ask you to do. Right?
If I might say real quick, I know you're busy. They have a city ordinance. That's why you can't lay at 11. But I was recently jumped. I got my medical records.
Look, don't tell me because I've got a bunch of DAs. I don't want you to say something that hurts the case. Let me give you a lawyer. Everything you say, when you want to tell me, tell the lawyer, and then they can tell me what.
I understand.
Okay.
Because the defendant works this location and we're not in contact with this location.
What is this? What is this
It's
place?
in the hospital building downtown.
That's the tongue. That's where I was at.
Don't go back, please. The problem is I don't want you to run into the security officer. Then more bad blood comes up. They found more charges. That's why.
I understand. I never said that. I ain't tripping. I already filed a motion for discovery inspection. So I didn't even have a bag on me.
Don't worry about it. We'll take care of you. I'll have you sign a reset with Victoria. We'll have you take a seat. Let me find you a lawyer. and
Yes,
then-
sir.
Okay, please.
Right this way.
If you can file this, please, the condition. No going back. Sorry?
Whenever you're ready to sign.
Yeah. I thought I signed it. Yeah, I signed it already.
You didn't know just now.
Yeah, so we can get them out. Mr. Lechuga, come up. We'll have you sign your condition. We'll get you out. You, Jessica Ariza? Ariza, come on up. Ariza, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Okay.
Okay?
On March 9th, 2025, in Harris County, Texas, officers were dispatched to a suspicious person call. Officer met with the witness who stated that the defendant was looking for her children and was at a nearby residence. The officer then made contact with the complainant at the residence, who stated the defendant had been intoxicated at a family gathering earlier, and they began to argue at home before the defendant assaulted the complainant. The defendant admitted to striking the complainant with the television. The officer noted the complainant to be bleeding from his face. The complainant is her ex-husband.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to have any contact with this complaining witness and not to be in possession of any weapons. Do you see a protective order that has been issued in this?
It needs to be, signed.
Okay, ma'am, I'm issuing now what's called a magistrate's order for emergency protection that identifies Mr. Roberto Baron as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes.
If you violate this court order, the state can and probably will file a violation of protective order. That is one of the worst cases you can pick up. Just don't have any contact. Don't use alcohol, any dope. You'll be fine.
Okay.
Just, I'm going to protect my city at all costs. And if that means putting you in, I'm going to do it in a heartbeat.
Okay.
Now, do you have the ability to hire a lawyer, ma'am?
No.
Do you work?
Yes.
Okay, you work full-time?
Yes.
Okay, I'll have you fill out an application. Do you have any children?
I have 3.
Okay, I'll have you fill out an application. Let me take a look at it to see whether you qualify and then we'll talk. Do not leave until you sign our bond conditions though. Don't worry, because since you'll be monitored for no alcohol, we'll have Fleischer do it. Okay, please. Deputy Miranda will give you an application. All right, good morning, Mr. Lechuga. Good morning. So you're charged with displaying a fictional license is a plate, right?
That's it?
You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 7th, 2025, at approximately 6:32 a.m., an officer observed a vehicle with expired registration as of June 2021. A traffic stop was initiated. The officer ran the license plate and it returned to a different vehicle. The officer made contact with the defendant, the sole occupant, and the defendant stated he purchased the vehicle 7 months ago and had not been able to register the vehicle due to long work hours. The defendant was detained and the defendant stated he had already received a citation for displaying a fictitious license plate by the LaPorte Police Department in January of this year.
Okay. Can you run his license, please? Does he have a license? Mr. Lechuga, I'm going to find that there's sufficient probable cause to go forward with your case. I am placing conditions on your bond now that you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, car insurance. God forbid you get into an accident and you maim someone and they come after you and sue you for $50,000. Got to hire a lawyer. You'll never crawl out of that hole. That's why you get car insurance, because you're not on purpose, or accidents for a reason. When you have insurance, they represent you. They'll get a lawyer for you. That's why you need it. If you don't have it, don't drive. Do you understand?
His driver's license is eligible.
Okay. So as long as you have those two, you may continue to drive. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Casanova and Mish. They'll tell you if and when you have to come back to court. She tells you that you pick up a new case, you start acting a fool in the free world, I will take it away from you. All right, I'll have you sign a resale with Victoria and then we'll get you out of here. Thank you.
There's no driving affidavit?
You were on bond for an assault case that have taken off on us at least 3 different times, and now you've picked up a new case. You were charged with failure to identify oneself, while being a fugitive from justice. On that case, you're now facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 7, 2025, at approximately 4:44 p.m., an officer observed a vehicle with expired registration as of December 2024. A traffic stop was initiated. The officer made contact with the defendant, the driver, who advised he did not have any form of ID on his person and provided his name as Daniel Escamilla, date of birth, April 24th, 1998. The officer did a search and saw the defendant did not resemble the Texas driver's license that came up for Daniel Escamilla. The officer found it for David Escamilla, defendant's real name, and saw there was an outstanding warrant. The Texas driver's license photo for David Escamilla resembled the defendant. The officer utilized mobile APIS and confirmed that the defendant was David Escamilla. The defendant admitted to providing the officer with his twin brother's information instead of his own due to the open warrant.
Do you see if he has a license? Can you check, please?
Yes, it's ineligible, Judge.
Okay, Mr. Escamilla, I'm going to have you sign an affidavit with me today. I don't give a rat's behind what is going on in your life. If you don't have a Texas driver license and liability insurance, you are not to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car. Do you understand?
Yes, sir.
You have a lawyer, Mr. Escamilla.
No, sir.
I'm going to appoint you a lawyer today. Your case, your assault case is 1,000 days old. We are going to figure out what happens with this case today. Can you appoint him a lawyer, please? If this case gets reset today, you will get an ankle monitor, and I'm going to send you for a drug test right now. I want to ensure that you're not using anything as well. You know what? Let's just do that now. Felicia, if you can send him, please. If you fail to take the test, if you fail to come back, I'm going to make your bond so high you'll have hair falling out. Do you understand?
Yes, sir.
The next time you take off on me and fail to come to court, so help me on those bonds. Do you understand?
Yes.
Take a seat for me. Joseph Martin?
Yes, sir.
So, Mr. Martin, you have a total of 4 open cases. You're charged with 4 counts of assault. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 8, 2025, officers were dispatched to 4527 Perry Street in Houston, Texas, in Harris County regarding an assault. The complainant, Hayes, stated that she was in a verbal argument with the defendant, and that led to her being pushed by the defendant. Complainant Hayes said that she hurt her hand due to being pushed into a car with the defendant and that she felt pain. The complainant, McDaniel, then stated that she confronted the defendant to see if her friend getting assaulted by the defendant. The defendant then started swinging and struck the back of Daniel's head, and that complainant felt pain as well. Complainant Powell then stated that she was assaulted by the defendant due to also trying to defend her friend, complainant Hayes. Complainant Powell says that he approached them to confront the defendant, and the defendant just started swinging and that she got struck by the defendant. Complainant Powell stated that she does not recall how that she was hit, but that she felt pain. Complainant Martin stated that she knows the defendant from school and they both attend TSU. The complainant Martin stated that she was trying to calm the defendant down but does not remember the physical assault due to her being knocked out unconscious by the defendant. Complainant Martin felt pain. A witness stated that she saw the whole incident and saw that the defendant was arguing with complainant Hayes and that the defendant started pushing complainant Hayes into a vehicle. Complainant Martin was then trying to de-escalate the situation and stated that when she saw complainant Martin get struck by the defendant and get knocked unconscious for approximately 2 minutes.
Is that number 3 or 2?
That's 4.
That's the 4th.
That's the 4th, Your Honor. The witness then stated that she saw the defendant punch complainant Martin on the left side of the face. The defendant admitted to being involved in the physical altercation with the complainant and pushing them away. The complainant 2 had a knot on the back of her head. Complainant 3 had a small swelling on the left side of her face. And complainant 4 had small swelling under her left eye and was transported to the hospital due to being unconscious.
All this happens at TSU?
It is. It was a party, yes, Your Honor.
Mr. Martin, I'm going to find that there's probable cause to go forward with your case. I'm now barring you from going to TSU.
Yes, sir.
I'm barring you now from going to TSU. I'm also ordering you as a condition of your bond not to have any contact with any of the complaining witnesses in this case, not to consume alcohol, illegal drugs, not to be in possession of weapons. If I find that you're a danger to my community, I will do everything in my power to take you off the street. Do you understand?
Sir, I understand. May I ask what this bar? Okay.
You have the ability to hire a lawyer, Mr. Martin.
No, sir.
Do you work?
Sir.
I'll have you fill out an application. Deputy Miranda will give you an application. I'll see whether you qualify for an appointed lawyer. I'm going to have you sign a receipt with Victoria. Then I'll have you meet with Felicia for your bond conditions. Life is way too short to sit in a box that's 6 by 9, man. Keep my city safe. Otherwise, it's going to go sideways real quick. You understand?
Yes, sir, I understand.
Okay, come on.
Thank you. I'll go.
Right this way.
I see. Okay, Mr. Mejorado, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 9th, 2025, at approximately 3:30 a.m., officers were dispatched in response to a motor vehicle that ran off the road. The officers respond to the defendant's motor vehicle, a Dodge Ram, in a grassy area adjacent to a service road on the East Freeway. Service Road in Harris County, Texas. The officer observed the defendant and walked over to the defendant walked over and advised that he was leaving the parking lot and lost control of the motor vehicle when he drove through the puddle of water. The defendant's motor vehicle left the road and got stuck in the mud. The defendant stated his friends were there helping him pull the motor vehicle from the mud. The officer observed glassy eyes, slurred speech, and odor of alcoholic beverage. The defendant stated that he did not have anything to drink, and the officers relocated him to JPC to continue the investigation. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The DIC was read and consented to Bragg, and the results were a .148 and a .143. It was identified by his Texas driver's license.
Okay, sir, I'm going to find that there's sufficient probable cause to go forward with the case. You look to see any prior DWIs, and if he has.
There's no prior DWIs, and his license is.
Okay, Mr. Mejorado, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Likewise, if I find that you're driving without insurance, your bond will be revoked. You will go into custody. You understand?
Sir.
Do you have the ability to hire a lawyer?
No.
I'll have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. We'll have you fill it out. I'll have you sign a receipt with Victoria. You'll get with Fleischer for your bond conditions. Then I'll take a look at it shortly. Please. Are you ready? Hey, good morning. You want to do the arraignment first or which one? Okay. Come up, man, please. So she has a co-defendant. Do you guys represent the co-defendant? Do you know?
No.
No?
I believe the defendant also has a felony because he had prior thefts on it,
Really?
but she is a first-time offender. And her, yeah. And her involvement in it is not as much as the co-defendants.
Ms. Ayala, you're charged with, you speak English, ma'am?
Yes, sir.
Okay, Ms. Ayala, you're charged with theft. Shh. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On March 9th, 2025, at approximately 5:43 p.m., an officer was dispatched to a Best Buy in Houston, Harris County, Texas, in regards to a theft. The call notes advised that the suspects had left the location in a red Dodge Challenger with a temporary tag that started with 74. The officer located a vehicle consistent with the description about 0.8 miles from the business. The officer was also given a description of the suspects. A traffic stop was initiated. The officer immediately recognized Defendant Sauceda from previous thefts from Best Buy. Defendant Sauceda stated he took 2 items from the Best Buy without paying. The passenger, who is identified by her Texas driver's license as defendant Ayala, and defendant Sauceda entered the store and went to the cell phone station. Defendant Ayala distracted the cell phone employee while defendant Sauceda used a pair of scissors to remove 2 cell phones and exit the store. Shortly after, defendant Ayala received a text message from defendant Sauceda, and she immediately left the store without purchasing any items. The total value was $1,499.99, and the 2 items were located inside the vehicle.
Don't talk about the.
Ms. Ayala, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to have any contact with the co-defendant in this case. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. I'm also ordering you and barring you from going to any Best Buy in anywhere. Do you understand? If I find that you pick up a new case, if I find that you violate these conditions, that's it.
Yes, sir.
So do you mind filing those conditions, no contact with the co-defendant, no going to any Best Buy, anywhere? And then now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, I will issue a warrant for your arrest. For now, I'll have you sign a reset with Victoria. We'll have you take your seat in the jury box. So we'll get your bond condition. We'll have you sign it. And after that, you'll be free to go. Okay, thanks.
Judge, I have 2 bond violations. The first one is Torres Noe. His bond violation is for failing to show up to a random UA. I tried reaching out to him, Judge. Apparently, he got deported. So that kind of explains why he's.
Sure about that? How do you know?
That's what the family told my office.
Got it. Okay, I'm gonna end up revoking it then, because I can't just leave it open. I'll leave it at 2501.
Yes, Judge.
Okay.
And then you reinstate if he's got.
I mean, let's see, but more than likely, like if it's not his fault, they just up and took him, then, you know.
Yeah, his family says he was detained by ICE and deported.
Just I would reach out to the family, let them know, hey, if you're gonna get him back, do it the right way. You know, like get permission first, and then if I see that they do that, then of course, absolutely, I would reinstate it. So who's second?
And then Judge, the second one is gonna be Lambert, John.
With an L.
Yes, Judge.
Come up, Mr. Lemberg.
And Judge, I spoke with Mr. Lemberg. He had a BAC of 0.03 on his interlock. I spoke with him about the incident. We talked about, let's just be honest about this and let you address it. We are asking for an admonishment because it is his first bond violation. He said he went out with friends on Friday, had some to drink. He didn't drive that night, but the following day he didn't know that he was going to be positive when he tried starting the car, and of course the ignition interlock picked on it. I did admonish him that, your bond conditions are no drugs, no alcohol whatsoever. It's not only when you're driving, but throughout the pendency of the case. He understands that now. He is just asking if you would give him an opportunity to change.
You had a WI 2 years ago. Now you've got another one. We tell you not to consume alcohol, yet it's happening anyways. So either you don't care about court orders or you have a problem.
Yes, Judge.
Have you seen how many people we put into custody?
Yes.
I'm now going to put a monitor on your ankle so I know that you're not consuming at all. I'm going to put a scram monitor that detects alcohol through your perspiration 24 hours a day, 7 days a week. I don't give a rat's behind what your next excuse is. If I find that you ever test positive for anything else again, I will lock you up. No more PR bonds. Do you understand?
Yes, Your Honor.
Your other ankle, I'm now going to put a GPS monitor and I'm going to give you a curfew of 9 p.m. to 6 a.m. If I find that you're out because I don't want you out in the middle of the night, likewise, you will go into custody. Do you understand?
Yes, Your Honor.
It is absolute no tolerance here for it. I don't care what your excuse is from now on. No means no. Do you understand?
Sure.
Okay.
Thank you, Judge. May we be excused?
Yes, ma'am.
Thank you.
Good morning, Mr. Villasana.
Morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 7th, 2025, at approximately 7 p.m., officers were dispatched to a person's town on the West Digital Road in Harris County, Texas. The officers spoke with the witness, who, the witness stated that the defendant was parked when he got to the location and was asleep in his motor vehicle. The vehicle was turned on with all the doors were off. The witness stated that he knocked on the window multiple times to see if the defendant wakes up, that the defendant did not respond to knocking, and that the witness had used a special tool to open the door and was found able to the defendant, who seemed a little bit off. The witness stated that the defendant had told him that he had been drinking a few hours prior to driving to the gas station, and that he observed a brisk man in the middle of the car, asked the defendant about it. The witness stated that the defendant had been in the hospital 3 days ago for alcohol problems. And another witness stated that multiple customers had stated that the defendant had been parked at the gas station, and when that gas station made access to witness to the cameras and saw the defendant's car had been parked there since 6:30. Witness 2 went outside to check on the defendant, and the defendant was asleep and tried to wake up the defendant by knocking on the door, but he did not wake up. The motor vehicle was on. The officer observed a strong odor of an alcoholic beverage, poor balance, and disorientation. He refused SFSTs and admitted to consuming alcohol a few hours prior. A open container of Jim Beam bottle was locked in a hidden compartment of the passenger seat, and an empty can of Four Loko was located in the center console. A styrofoam cup with a lid and a cup holder with a liquid matching the color of the liquid in that Jim Beam bottle was also found. The DIC was read and the defendant refused breath. The blood warrant was signed and executed and was identified by his Texas driver's license.
Are you telling me that he had alcohol in the car while driving?
Yes, Your Honor.
Mr. Villasana, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you not to drive any vehicle whatsoever for any reason. Do you understand?
Yes, sir.
If I find that you do, I can have a contempt hearing. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you to obtain a portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. If you have a problem with alcohol or illegal substances, you better address it. Because if you don't, and it becomes a problem, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
I am sending notice to DPS and I'm placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an interlock on it. I'm sending notice now to DPS in Austin so that every police officer in this state knows that if you're caught driving a vehicle and that vehicle doesn't have an interlock, they will take you to jail. Because I'm ordering you not to drive now, that's why I'm giving you a portable device. But do not drive. Do you understand?
Yes, sir.
You get no more warnings. If I find that you do, I'm going to lose it. Do you have the ability to hire lawyers, sir?
Sir.
Okay, we will give you time to go hire a lawyer. I'm going to have you swear to us that you're not going to drive. I will get you to Victoria where we will have you sign a reset. You will get with Fleischer your bond conditions. After that, you're free to go. Be careful, Mr. Villasana. Okay. You are Alejandro Castillo.
Yes.
Mr. Castillo, you're charged with failure to stop and give information. Essentially leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6th, 2025, at 9 a.m. Officers were dispatched to a crash at a location in Harris County, Texas. Upon arrival, the officer met the complainant. The complainant stated that she was sitting at a red light and she was struck by the defendant, and then the defendant left the scene. The complainant was able to get the vehicle's license plate. The complainant followed the defendant through a residential neighborhood where the defendant lost control of the vehicle and crashed into a house about a mile from the original crash. The complainant estimated damage to be around $2,500. It is not $100.
That's what I was gonna ask you. Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you in the jail because they sweep it every single day, every couple hours. If they find you in there, they will place an immigration detainer on you and you will be stuck like Chuck in there until this case is over with. And then you will be shipped off to immigration where you will sit. It takes 9 months just to get a 911 tape here. So you will sit for that time, then shipped off to immigration. I don't know what your status is, but if you're not here with permission, you better live with a halo over your head and not violate any conditions that I put on you now. I'm ordering you not to drive. You do not have a Texas driver license. You do not have liability insurance. You are not to drive. I don't care what is going on in your life. I don't care that you need groceries. I don't care that a baby needs to go to the hospital. If you don't have a Texas driver license and liability insurance and approval from us, you are not allowed to drive. If I find that you break this condition, your bond goes bye-bye. You have the ability to hire a lawyer.
¿Usted puede ocupar su propio abogado si no? No.
I can have you fill out an application and I will take a look to see whether you qualify for an appointed lawyer. I need to know everything about you. We are filing conditions that you're not to drive. Do not leave until you sign our bond conditions. Deputy Miranda is now going to give you an application for an appointed lawyer. I will have you sign a receipt with Victoria and then we'll have you take a seat in the jury box, sir.
Was that financial affidavit?
Yeah. Good morning, Mr. Reyes.
Good morning, Your Honor.
Always a pleasure.
Good to see you today. Same here, sir. Look sharp, Judge.
You're Miss Grab?
Yes, good morning.
Good morning, ma'am. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 9th, 2025, at approximately 1:08 a.m., an officer observed a vehicle on the 5,000 block of Westlow Road, Harris County, Texas, speeding going 58 miles per hour in a 40-mile-per-hour zone. This was confirmed by Dr. Rear. The officer followed the vehicle and observed the vehicle to fail to maintain a single lane several times. A traffic stop was initiated. The vehicle did not initially stop. The officer initiated sirens, at which point the defendant's vehicle increased in speed and continued to fail to maintain a single lane and failed to signal lane changes to get around another vehicle as the officer was in pursuit. The vehicle finally came to a stop. Officer made contact with the defendant, the driver, and sole occupant of the vehicle, and observed the defendant to have red, bloodshot eyes, thick, slurred speech, and the strong odor of an alcoholic beverage upon her breath. The defendant admitted to coming from a wine bar and said she had 2 glasses of wine. As the FSTs were conducted, 6 out of 6 clues observed on the HGN, 5 out of 8 clues observed on the walk and turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read, and the defendant consented to a breath test. The results were 0.100 and 0.101.
You said she was going 50 speeding or 40?
58 miles per hour and 40 miles per hour.
Got it. Okay. All right. Ms. Grab, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sure.
You have a lawyer. He will take care of you. Because you do, I will waive your appearance. Just stay in touch with him and he'll tell you if and when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. Oh, does she have a license?
Yes.
No prior DWIs?
No prior DWIs.
Okay, we'll have you sign a reset, Victoria. You're not allowed to drive unless you have valid liability insurance as well. If you don't have car insurance, do not drive. That is a condition of your bond as well. Do you understand?
Yes, sir.
Okay, I'll have you sign a reset, Victoria. You'll get with Fleischer your bond conditions and you're free to go.
Thank you.
Take care.
John C. Joseph, it's my understanding that you want to talk to him and see why he didn't appear in court on his last court date.
So this is basically an arraignment.
Yes, sir. I understand that we were going to do it as an arraignment.
He's been AWOL. It's now 400 days, 350 days old. Mr. Joseph, you're charged with 2 cases. You're charged with burglary of a motor vehicle. You're charged with unlawful carrying of a weapon. Your cases are now 352 days old. It's time to decide what we're going to do. Do you have offers on these cases?
No, sir. We're still waiting for the security video.
We do have an offer, but yes, we are waiting on the security
I
video.
need you to get on it
Absolutely.
like yesterday.
Yes.
I'm ready to set this case for trial. Way too much drama, and I'm not gonna just.
Yes.
Mr. Joseph, I'm now going to put an ankle monitor so I know where you are at all times. If I find that you have one on now, you take off on me again, I'm gonna make your bonds extremely high. Do you understand? I will give you a big flight risk and the bonds will go very high. At some point, someone's gonna stop ponying up all this money. You're just giving free money to bonding companies every time you take off, man. That's all you do. On your burglary case, you're not to have any contact with the complaining witness in these cases. You're not to be in possession of weapons.
Judge, did you say you already have something going
Yeah.
Is it from Harris County?
Mm-hmm. I turned myself in the other day and they ain't doing nothing better.
Don't say anything. I don't want you to say something. Perhaps the magistrate put it on.
I don't see any magistrate conditions, but
He's got 2 cases. Look at the other one, please.
neither of them were supervising an ankle monitor board. We had one on him back in April of last year, but we haven't been supervising it since June due to the warrant.
All right, I want to go back to the original bond conditions that had a curfew with the monitor on now. No alcohol, no dope. What do you do with yourself these days, Mr. Johnson? Mr. Joseph?
I just started looking for a job. No, sir. I just started looking for one, filling the application.
I'm going to bring you back in 2 weeks. I want to see what you have done to get a job. Did you graduate from high school?
No, sir.
Then that's what we're going to also work on as well. I want to see what you've done to start working on your GED as well. I'm giving you 2 weeks. If you've not done anything, it's not going to go well for you. Do you understand?
Yes, sir.
Okay. All right, Mr. D, we'll give you a couple weeks, but I want him back in 2 weeks here to see what we've done to either get a job or get his GED.
Yes, sir.
Okay, if nothing, then it doesn't go well.
Yes, sir.
All right. Hi, Vic. What's up? What's new, man? Good to see you.
Good to see you.
Happy Friday.
Happy Friday.
You mean
I'm gonna do a PSI on it rather than fully upstairs, so it's made my Friday a lot better.
scary though?
It is.
No, let me tell you, I did a PSI once where I was basically going to get probation and then got smacked with 25.
And it is enhancement. I'm on. And it's working and it's got a lot of support. And it's a really silly case. It's a silly case. It's evading arrest, but it's.
I trust you.
Yeah.
You know, you're the best, but PSI, it's just,
There's always risk there, but the state was at 15, so.
yeah.
Melgar. Daniel Melgar. This is my fault, Judge. PTI packet. Yesterday.
Okay.
To Abigail and.
Well, not to Judge Geis, right?
Yes.
Okay.
I think
everything's submitted?
Everything's submitted, all the discoveries turned over. The point was 6, so it's just a little bit above the thinking.
Why? So were you denied?
You're told to submit a mitigation packet, yeah.
Okay, so it wasn't a denial and then you appealed,
Correct, correct.
right? They just submitted a mitigation package.
Resubmit mitigation
Got
packet.
it. All right, we'll give you a week.
Sounds good, Judge.
Hopefully we can have a decision within a week.
I hope
If no
so.
decision is made, I will waive the appearance. We'll give them a little bit more time.
Okay.
If it's approved, your guys got to be here so we can send it for a TRS.
Okay.
Okay?
Sounds good.
Yes.
And then we'll just come back. Hopefully they got it within a week to make the decision or not.
Sir,
Yeah.
it's good.
Okay.
Judge, thank you. Nice to meet you.
Good luck, Vic.
Thank you, sir.
Are you on probation or parole at this time?
No.
You were on parole in 22. Is that over now?
Yeah.
Okay. So I don't show any holds on you now.
It's no hold.
I don't see any. Do you guys? You guys? Yeah, we don't see any holds. But if you continue with what this has happened and this keeps happening, the sentences just get longer, longer, and longer. All of it self-control, Mr. Kaufman. You're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 15 days in jail with credit for the 7 days that you've done. You need to understand that this is going to go on your record. From now on, you're facing a minimum of 90 days in jail. Do you understand? So Lori, the trespass is being dismissed.
Are y'all dismissing the trespass?
Believe so, yes, Your Honor.
We thought we were, we will assist trespass.
There is a trespass, right?
Here's a trespass. Was there plea paperwork for the trespass?
So they're going to dismiss the other case that you got. But like I said, you're still facing a minimum of 90 days in the future. So you pick up another case, it's just going to be a long time. Do you understand? Yeah.
Yes.
Yeah. But if you want something, if you need something, we have services for you. If you need a place to sleep, you need food to eat, we got you. All you got to do is ask. But this, you're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal, Mr. Kaufman. So once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense, sir? Guilty or not guilty? I'm going to find you guilty. I'll send you to it. Good luck, sir. Thanks a lot.
Judge, can I start with Alator Aristelsi for bond violation? She tested positive on 3/4. On March 4th for cocaine, Judge.
Can you bring her up, please?
And Judge, this is her first bond violation. If you'd be willing to give.
Ordered you not to use, you're now testing positive for cocaine. That's unacceptable. No, I'm not going to let you go. Marijuana, alcohol. No, you're testing positive cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm going to revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No. I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you set on that, Judge?
$5,001.
And Judge, I have two more. I have Enrique Flores.
Enrique Flores, come up.
And Judge, on this one, he was in lockout since March 6th. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a burst bond violation with him missing.
I think might be the second, Judge.
Judge, yes, this is the second. The first one was for the same thing.
Take your time, no rush. Deputy, ain't you going? We need your help. No? Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time?
No, Judge.
Unacceptable. He now goes with you.
What would you set his bond at, Judge? 5,000?
And then, what's the last name again?
Flores, Judge?
Thank you. Yeah, 5,002.
5,000?
Yes.
All right, Judge, and I have one more, and it's Gomez.
Okay. Jorge Gomez, come up.
So Judge, he did take a drug test today because he had failed to report for a drug test on February 21st, and he tested positive for marijuana.
You see how many people we've taken into custody? I ordered you not to use, and you're now testing positive. If I find that you ever test positive again, I will put you in jail. Do you understand? When I say don't use, I absolutely mean it. You will get tested in 50 days. If I find that you continue to use, into jail you will go. Do you understand?
Yes, Your Honor.
Yes. Absolutely no tolerance here for it. And the next time you miss an appointment, likewise, you will go to jail.
Yes, Your Honor.
Thank you, Judge. In 50 days, Judge?
Yeah, reset 50 days must appear.
Okay, thank you, Judge. Thank you, Judge.
All right, so Mr. McGee, you've worked out an incredible, well, not you, your lawyer has worked out an incredible deal. You're charged with five, it's 5 open cases, right? Shh. You're charged with evading arrest, failure to identify oneself, evading arrest, theft, burglary of a motor vehicle, and I think that's it, right? But as part of the agreement, you're going to plead guilty to the burglary of a motor vehicle and the evading arrest. You need to understand that both of these cases are enhanceable cases, meaning if you pick up another one of these cases, it's very possible they charge you with a felony offense. Now, on the burglary case, it may be 2 or 3. I think it's a third, it's a felony. But on the evading case, you pick up a second one, you're looking at a felony charge, years instead of days. You understand? So I don't know who you're hanging out with. I don't know what you got going on in your life, but you got to surround yourself with better people, because you start the wrong people, they're going to bring you down. Don't become another statistic. We have enough Black and brown people in custody now. Don't become a statistic. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you plead guilty to these cases. You can't do anything else. It goes on your record. It'll be there forever. So how do you plead to both cases guilty? Mr. McGee, if you need anything, just come back, talk to me. I'll get you whatever you need. If you want a place to stay, food, cell phone, tablet, we can work just about anything to get you what you need. It's never a problem.
Yes, sir.
But would you get out there, you get on the street, you got to be careful, man. You get for one life. You don't get another one. There's no redos. Good luck, man. Yes. It's 30 days. I'm sorry, 30 days in jail, credit for the 29 and 31.
Okay.
It's Tyron, whatever you'd like.
So we can, maybe we
I don't know
can.
about a bond is because it's kind of.
Yeah, no, we don't.
Oh, got it.
And maybe we can review PC. I think we're in agreement with the trespass. There was no trespass for the quote.
I'm always happy to hear PC. Let's do it.
Yeah.
Jay, you want to do it or no?
Let's do it.
Okay.
All right.
What's the contract number?
255-4294.
It's on document.
Oh, it is?
Yeah.
Sorry. Okay. On March 4th, 2025, at approximately 10:30 a.m., officers were conducting an investigation for an evading case at Oyo Hotel. The officer made contact with the manager of the hotel, who showed surveillance video that showed a male who had been given several trespass warnings and stated he refused to leave and comes back all the time. The suspect was a black male with a jean jacket and dreads. There is also a posted no trespassing affidavit on the front of the hotel. The officer spotted the male and attempted to make contact with him. The officer approached the defendant and the defendant began walking away, and the officer advised him to stop. The officer placed his hand on the defendant's arm and the defendant began running down the stairs carrying his bicycle. While running, the defendant used his bicycle as a barrier and shoved it towards the officer, hitting his left knee. The defendant continued to run around the motel, and he grabbed his bicycle, which he left on the left side of the building, and the officer was able to take the defendant into custody after a taser was used. The defendant was identified by his Georgia ID card. The defendant has an open probation violation warrant out of Louisiana for a weapon charge.
So he's at a hotel.
Yeah,
Was he, you're saying he's not allowed to be there.
correct.
Are you saying he was?
There's no trespass warrant on file with his name on it. I believe there's a homeless encampment near this hotel, off Highway 6. And so a lot of the homeless people go back and forth. Mr. McGee is homeless. I don't know. It's not clear whether Mr. McGee is the person that they're referring to. I know he's a black male with dreads, but he's never received a trespass affidavit. And there's no information of that.
You said that there was one.
It says in the DIMS that the complainant pointed out the defendant on surveillance video and said, I have told him several times, I've given him several trespass warnings and he refuses to leave and he comes back all the time. And then also it
Maybe
is
they were
stated in the
verbal.
DIMS that there's a trespass affidavit posted on the front of the hotel.
Okay, but that doesn't mean anything. That just means like no trespassing.
And usually with
It's
the
like,
trespass affidavits, he was there visiting someone that stays there. So in all of the loitering with convenience stores and things of that nature, that applies to people that are there without any kind of, if you're not buying anything, visiting anyone. So he was visiting one of the people that was staying there. And that's why he had his bicycle. The police, I basically just grabbed him and he was coming down the stairs. So I don't think we have a valid trespassing case because there's no affidavit with his name on it. And if he was there legally visiting someone at the hotel.
is a verbal trespass warning sufficient?
I would disagree, Your Honor, especially because this is, and I guess we would need to see what their trespass affidavit says, because usually the ones at the convenience stores, I've dealt with this a lot, it excludes people that are there legally.
I mean, I get that the penal code doesn't say that it has to be in writing though.
Mhm.
You know, I mean, it could say, hey, I don't want you here. Don't come here anymore.
Mhm.
So
But then if we take that blatantly, that there's a trespass affidavit, then that means.
but then anybody could say,
That's correct.
right, I get it.
wouldn't
I
be
get
able to
it.
Go in and visit my aunt. She was staying at that hotel, so it can't be that restricted. If he was there with his bicycle, he wasn't just out in the front visiting someone, he was up inside of the hotel with his bicycle coming down. He was there visiting someone. So I don't think that there's any information or evidence that says that.
So the state would concede that a general trespass affidavit would not be enough. So it would be due to the verbal trespass warnings that were given to him several times by the manager and him refusing to leave the location.
So where do we go from here? Like, how are we gonna?
My goal is, Judge, or my hope is that the state, in looking at this and knowing that he has a case out of New Orleans, which he's on parole on, I'm hoping that they will resolve these issues. I have spoken with his parole officer, and he, bond or not, he is going to have to sit in jail another 14 days to be extradited. But because he's on parole, I cannot plead to anything because I want him to get to New Orleans and have the ability to potentially get terminated.
They're coming, obviously, right?
They are,
But it's Louisiana, so they should be here.
it'll be pretty fast.
I mean,
The larger part of it's not Louisiana jail, it's not directed to Harris jail, this is a parole violation. I think what council is saying is that for whatever they condemn for the parole violation, they're gonna have it before the board. Well, obviously, if he takes a conviction, that's gonna affect his eligibility versus a dismissal.
But there was already a warrant regardless.
Right.
Something happened regardless. So perhaps he absconded or.
Because he had been here homeless off the grid, so because he had no residence and things like that. And so that's why. But for conviction here.
Right. The only problem, Ms. Sparks, is that the 14 days or any time it's told,
As long as this is going on.
well, because he's not made, you know,
Yeah,
I think one of them.
I'm showing both are,
yeah, no,
he's not made bond on
we
either
were
of them.
told to, it made no sense to me.
If I may, last Friday, we revoked the bond on the local cases to keep Louisiana from coming to get him.
Oh,
that's this one?
I don't remember
Yes.
that. I didn't remember that. I thought it was someone else that we.
Yeah.
Okay, so,
So that way you wouldn't have to go back and forth and deal with the same.
right, you're right, you're right. No, she's right, because the problem is that if they come and get him, he goes over there, then a hold gets placed on these, the exact same situation. So
I trust Blaze, and his staff.
Guys.
I'll stand down.
whatever you want to do, if you want to set it maybe just a couple days to look further to see if there is anything, if you could probably perhaps somehow get that he's actually visiting someone.
Yes, Your Honor.
No.
Okay, yes, Your Honor, I'll stand down.
Yeah.
Thank you.
You know, Mr. Flores, I really don't know what it's going to take to get your attention that we're not going to stand for anyone endangering our public. Really. I mean, you've had in the last 3 years, 3 very serious cases, and now you're picking up a DWI. All of them are dangerous cases. What's it going to take? A 25-year sentence? Is that what it's going to take to get you to realize? You know, all the stuff here is things that if you just think, they don't have to happen. All the time, all the money, all the just that you spend coming here can all be avoided by not using. You know what I mean? That's all it takes. From now on, what we're doing today, you're now facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? There are more proverbial slaps on the wrist. What you're pleading to now is a DWI. This DWI will go on your record. It will be there for the rest of your life. You can never take it off. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this case, like I said, it'll go on your record. You can never take it off. Do you understand?
Yes, Your Honor.
You know, the other thing is this, is that your lawyer is asking to waive all the fines and fees. If you ever pick up another DWI, it is a $6,000 surcharge that you will be required to pay. And if you don't pay it, you sit 1 day for every $100 you owe. If you want to get lit, 52 beers, 32 shots of tequila, take a freaking Uber. $40 wherever you want to go in this damn city. Don't kill anyone. How do you plead to the DWI? Guilty or not guilty?
Guilty.
I'm going to find you guilty and I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you've done. I'm going to suspend your license for 180 days. Don't get into a car. Driving on a suspended license case is just like a DWI. You pick one up, you're going to be right back in here, and it's just not going to go well for you.
Yes, Your Honor.
You understand?
Yes.
All right, good luck.
Thank you, Judge.
I have, Mr. Escamilla and, Ms. Victoria says we need to approach you on the reset because you sent him for a drug test, Judge.
Positive for what?
THC, Judge.
No more.
Yes,
You
sir.
are not allowed to use. It is a condition of your bond. I will give you up to 50 days, and I'm going to test you again. If I find that you continue to use, I will put you in jail.
Yes, sir.
No more PR bonds for you.
Yes, sir.
You take off on me again, it's really not going to go well for you. Do you understand?
Yes, sir.
Okay, I put a GPS monitor on him and I've given him a curfew because he's taken off on us many, many times. His case is 1,000 days old. So I'll give you a reset, but I think that we were waiting on, is discovery complete on the assault case?
It says the only outstanding thing is a photo from the complainant.
Okay, if you can please
Yes.
get that.
And Judge, just for the record, I was just appointed today. Okay.
No, I'll give you time.
Thank you. Thank
Sure. But I'm gonna test you like crazy.
Yes,
Just
sir.
get ready.
I'm working. Yes.
It's on your ball.
Yes, sir. Understand.
It's your responsibility to stay in touch with her too. If she tells her she can't get a hold of you because you're ducking and dodging, likewise.
Yes, sir.
Jail you will go.
Understand.
All right?
And,
Okay, Ms. Tucci.
Yes, Judge, we've had a long talk this morning.
Good.
And he was really good about communicating earlier.
and,
Okay.
for my
Yes.
curfew, I work a night shift. I work 5 PM to 5 AM, so.
Judge, can it change to allow him to work?
I want proof. Show me proof. I'm not gonna take your word
All
for it.
right, but she'll send it to me and by Monday I'll bring it in and we'll adjust. Does he need to be here if you're gonna adjust the curfew or can I just come show you?
I want, bring me a legitimate proof and we can
And then we'll
talk.
talk.
And then, but remember, the GPS monitor tells me exactly where you go
Yes, sir.
at all times. So if you deviate,
Just working back, yes, sir.
all right, okay.
I'll get the proof, Judge. Thank you so much.
Yes, ma'am.
All right, go have a seat real quick.
Good morning, Mr. Goff. The reason that we took you into custody now is because you were on deferred for an aggravated assault of a family member. It looks like that's in warrant status now and no bond, actually. With us, you've picked up a possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 5th, 2025, at approximately 11:50 p.m., an officer observed a vehicle parked in a handicap parking space with no displayed license plate or placard and then leave the parking lot. The vehicle had expired registration as of July 2024. A traffic stop was initiated. The defendant was the driver and he was ID'd by his Texas ID card. The officer observed the strong odor of marijuana emitting from the vehicle and the defendant admitted to being in possession of several small plastic bags of marijuana under the driver's seat. A probable cause search was conducted and 4 bags were located under the driver's seat, 0.154 ounces.
All right, Mr. So he doesn't have a license, correct?
His driver's license is eligible, Your Honor.
Mr. Goff, I'm going to find that there's sufficient probable cause to go forward with the case. I'm not putting any conditions on your bond now. Just behave. That's all I'm asking you to do. You know, you're on felony probation. You're supposed to have a halo over your head, you know? When you don't, bad things happen, as you now see. Can you go ahead and appoint him a lawyer now? So I'm going to appoint you a lawyer so that you can speak to someone. We'll take you into custody now. You'll probably hit felony court Monday, and then we'll just give you a reset of like a week or two to figure out what happens. Okay? All right, man.